Remedy. The relief or redress granted by a court to a party who has suffered a legal wrong, representing the court's answer to the question of what justice requires once liability has been established, and taking the form of either monetary compensation, court-ordered action, or a declaration of rights. Legal remedy. A remedy available at common law consisting primarily of monetary damages, historically the only form of relief available in courts of law as distinguished from courts of equity, and still the default remedy in most civil disputes. Equitable remedy. A non-monetary form of relief developed by courts of equity to address situations where money alone cannot adequately compensate the injured party, including injunctions, specific performance, rescission, and constructive trusts. Adequate remedy at law. The threshold question in equity requiring a court to determine whether monetary damages would sufficiently compensate the plaintiff before granting equitable relief, since equity traditionally intervenes only when legal remedies are inadequate. Inadequacy of legal remedy. The showing required before a court will grant equitable relief, establishing that money damages would not fully or fairly compensate the plaintiff for the harm suffered, typically because the harm is ongoing, irreparable, or involves a unique subject matter. Cumulative remedies. The principle that a party is not required to choose between available remedies at the outset and may pursue multiple forms of relief simultaneously, allowing the court to fashion the most complete and appropriate response to the wrong committed. Election of remedies. The doctrine requiring a party to choose between inconsistent remedies once they have taken a definitive position, preventing a party from simultaneously pursuing contradictory theories of relief, such as both affirming and rescinding the same contract. Provisional remedy. Temporary relief granted by a court before final judgment to preserve the status quo, prevent irreparable harm, or protect assets during the pendency of litigation, including temporary restraining orders, preliminary injunctions, and attachments. Final remedy. Relief granted by the court as part of its final judgment after the merits of the case have been fully adjudicated, as distinguished from provisional or interim relief granted during the course of the litigation. Make whole. The fundamental principle of compensatory relief requiring that the remedy restore the injured party to the position they would have occupied had the wrong never occurred, neither overcompensating nor undercompensating for the harm suffered. Compensatory damages. The primary form of monetary relief in civil cases, designed to compensate the plaintiff for the actual harm they suffered by restoring them financially to the position they would have been in had the defendant's wrongful conduct not occurred. Special damages. Also called economic damages, these are the quantifiable out-of-pocket financial losses the plaintiff suffered as a direct result of the defendant's conduct, including medical bills, lost wages, property damage, and future lost earning capacity. General damages, also called non-economic damages, these compensate for real but inherently difficult to quantify harms such as pain and suffering, emotional distress, loss of enjoyment of life, loss of consortium, and disfigurement. Punitive damages, monetary awards exceeding the plaintiff's actual losses, imposed not to compensate but to punish the defendant for particularly egregious, malicious, fraudulent, or reckless conduct, and to deter similar behavior by the defendant and others in the future. Nominal damages. A small symbolic award, often just $1, granted when the plaintiff has proven a technical legal violation but has suffered no measurable actual harm, vindicating the right that was infringed without providing substantial financial relief. Liquidated damages. A pre-agreed sum specified in a contract that both parties agreed in advance would serve as compensation in the event of a breach, enforceable when it represents a reasonable estimate of anticipated damages rather than a penalty designed to coerce performance. Consequential damages. Losses that flow naturally from the defendant's wrong, but are not the direct and immediate result of it, recoverable only when they were a foreseeable consequence of the breach or wrong that the defendant knew or should have anticipated. Incidental damages, costs reasonably incurred by the injured party in connection with a breach of contract or other wrong, such as expenses of inspection, transportation, and care of goods, which are ancillary to the main consequential losses. Treble damages, a statutory remedy multiplying the plaintiff's actual damages by 3, available under certain statutes, such as antitrust laws and some consumer protection acts, as a means of deterring particularly harmful conduct and incentivizing private enforcement. Statutory damages, a fixed amount of damages specified by statute that a plaintiff may recover without proving actual harm, commonly available in intellectual property, consumer protection, and privacy cases where actual damages are difficult to quantify. Restitutionary damages, damages measured not by the plaintiff's loss but by the defendant's gain, designed to strip the wrongdoer of the benefit they unjustly obtained at the plaintiff's expense, preventing the defendant from profiting from their own wrong. Expectation damages, the standard measure of damages in contract cases designed to put the non-breaching party in the financial position they would have occupied had the contract been fully performed, compensating for the benefit of the bargain that was lost. Reliance damages, an alternative measure of contract damages compensating the non-breaching party for expenditures made in reasonable reliance on the contract, designed to restore them to the position they were in before the contract was made. Restitution damages, the recovery of a benefit conferred on the breaching party, designed to prevent unjust enrichment by requiring the defendant to return the value of what they received from the plaintiff under the now broken contract. Mitigation of damages, the plaintiff's legal duty to take reasonable steps to minimize their losses after being harmed, preventing recovery for losses that could have been avoided through reasonable effort, and reducing the overall damages the defendant must pay. Future damages, compensation for losses the plaintiff will suffer in the future as a result of the defendant's wrong, including future medical expenses, lost future earning capacity, and ongoing pain and suffering, typically discounted to present value. Per diem argument, a damages calculation method used in closing argument assigning a specific dollar value to each day or other unit of time that the plaintiff suffers pain and suffering, multiplying that amount by the expected duration to arrive at a total figure. Collateral source rule, the principle that damages awarded to the plaintiff are not reduced because the plaintiff received compensation for the same loss from an independent source such as insurance, preventing the defendant from benefiting from the plaintiff's own prudent foresight. Injunction, a court order compelling a party to do something or, far more commonly, to refrain from doing something, representing the court's most powerful equitable tool for preventing ongoing or threatened harm that cannot be adequately addressed through monetary compensation alone. Prohibitory injunction, the most common form of injunction ordering a party to stop engaging in specific conduct, such as ceasing an unlawful business practice, stopping construction, or refraining from contacting a protected person. Mandatory injunction, a more intrusive form of injunction ordering a party to take affirmative action rather than merely cease conduct, such as requiring a party to remove a structure, restore property, or take steps to remedy an ongoing harm. Temporary restraining order, TRO, an emergency form of injunctive relief granted without prior notice to the opposing party, or on very short notice, when the moving party demonstrates that immediate and irreparable harm will occur before a full hearing can be held on a preliminary injunction. Preliminary injunction, a form of injunctive relief granted after notice and a hearing, designed to preserve the status quo during the pendency of litigation until a final determination on the merits can be made, typically lasting until the case is resolved. Permanent injunction, a final injunctive remedy issued as part of the court's ultimate judgment after a full trial on the merits, imposing an indefinite ongoing obligation on the enjoined party that remains in effect unless modified or dissolved by the court. Ex parte injunction. An injunction granted without advance notice to the opposing party, available only in genuine emergencies where the harm is so immediate and severe that waiting for notice would cause the irreparable harm the injunction is designed to prevent. Injunction bond, a security deposit required of the moving party when seeking a preliminary injunction or TRO, designed to compensate the opposing party for wrongful restraint if the injunction is later found to have been improperly granted. Four-factor test. The standard legal framework for evaluating a preliminary injunction, requiring the moving party to demonstrate a likelihood of success on the merits, a likelihood of irreparable harm without the injunction, that the balance of hardships favors the injunction, and that the public interest would not be disserved. Irreparable harm. Harm that cannot be adequately remedied through monetary compensation after the fact, because it is ongoing, imminent, or involves unique or intangible interests, serving as the essential justification for equitable relief rather than waiting for a damages award. Balance of hardships. The equitable weighing of the harm the moving party will suffer without an injunction against the harm the opposing party will suffer if the injunction is granted, used to determine whether the equities favor granting the requested relief. Status quo. The existing state of affairs at the time a lawsuit is filed, which a preliminary injunction is typically designed to preserve during litigation to prevent either party from taking actions that would make the ultimate remedy meaningless. Dissolution of injunction. The court's termination of a previously issued injunction, either because the underlying circumstances have changed, the enjoined party has demonstrated compliance, or the injunction is found to have been improvidently granted. Modification of injunction. The court's adjustment of the terms or scope of a previously issued injunction to address changed circumstances, new information, or practical difficulties in compliance that were not anticipated when the original order was entered. Anti-suit injunction. An injunction ordering a party to refrain from filing or pursuing litigation in another court or jurisdiction, typically issued to prevent duplicative proceedings, forum shopping, or harassment through multiple simultaneous lawsuits. Anti-SLAPP. A legal mechanism, strategic lawsuit against public participation, allowing defendants to quickly dismiss lawsuits filed primarily to silence or burden critics, whistleblowers, or public participants, often available through special motions that shift attorneys' fees to the plaintiff if the suit is found to be retaliatory. Contempt of court. The court's power to punish any person who willfully disobeys a court order, disrupts court proceedings, or otherwise shows disrespect for the court's authority, serving as the primary enforcement mechanism for all court orders, including injunctions. Civil contempt. Contempt imposed to coerce compliance with a court order or to compensate the opposing party for losses suffered due to noncompliance, characterized by the ability of the contemner to purge the contempt by complying with the order. Criminal contempt. Contempt imposed to punish past disobedience of a court order or disrespectful conduct toward the court, characterized by a fixed punitive sanction that cannot be avoided through future compliance. Direct contempt. Contemptuous conduct occurring in the presence of the court, such as outbursts, disrespectful behavior, or refusal to answer questions in the courtroom, which the judge may address immediately and summarily without a separate hearing. Indirect contempt. Contemptuous conduct occurring outside the courtroom, such as violation of an injunction or failure to comply with a discovery order, which requires a separate hearing with notice and an opportunity to be heard before sanctions may be imposed. Contemner. The person found to be in contempt of court who is subject to the court's sanctions until they comply with the underlying order or until the court determines that the contempt has been sufficiently punished. Purge. The act by which a contemner in civil contempt eliminates their contempt liability by complying with the court order they had been violating, entitling them to be released from any ongoing sanctions upon demonstrating compliance. Coercive contempt sanction. A penalty, such as daily fines or confinement, designed to pressure the contemner into complying with the court's order rather than to punish them for past non-compliance, continuing until compliance is achieved. Punitive contempt sanction. A fixed penalty, such as a fine of a specific amount or a definite jail term, imposed to punish the contemner for past defiance of the court's authority, not subject to purging through subsequent compliance. Show cause order. A court order directing a party to appear before the court and explain why they should not be held in contempt or why some other sanction should not be imposed, placing the burden on the responding party to justify their conduct. Contempt hearing. A formal proceeding in which the court determines whether a party has violated a court order, and if so, what sanctions are appropriate, providing the accused contemner with notice and an opportunity to be heard before punishment is imposed. Declaratory judgment. A court ruling that definitively establishes the legal rights and obligations of the parties without ordering any specific action or awarding monetary damages, providing clarity about the legal status of a disputed matter before it ripens into a full-blown controversy. Declaratory relief. The remedy obtained through a declaratory judgment action consisting of a judicial declaration of rights that resolves legal uncertainty and guides the party's future conduct without requiring a showing of actual present harm. Ripeness. The constitutional and prudential requirement that a dispute be sufficiently developed and concrete before a court will hear it, ensuring that declaratory judgments are not issued on abstract hypothetical questions, but only on genuine existing controversies. Actual controversy. The requirement that must be satisfied before a court will issue a declaratory judgment, establishing that a real and immediate dispute exists between parties with adverse legal interests, not merely a theoretical or anticipated future disagreement. Advisory opinion. A judicial opinion on a legal question that is not tied to an actual case or controversy, which federal courts are constitutionally prohibited from issuing, but which some state courts may provide to government officials or legislative bodies under limited circumstances. Declaratory Judgment Act. The federal statute authorizing courts to issue declaratory judgments in cases of actual controversy, providing parties with a mechanism to resolve legal uncertainty without waiting for the opposing party to take action that would trigger traditional litigation. Insurance coverage declaratory action. A common use of declaratory judgment relief in which an insurer or insured party asks a court to determine the scope of coverage under an insurance policy before or during underlying litigation, resolving disputes about whether the insurer has a duty to defend or indemnify. Preemptive declaratory action. A lawsuit filed by a party who anticipates being sued, seeking a declaration that they have no liability or that their conduct is lawful, allowing them to choose the forum and frame the issues before the opposing party initiates traditional litigation. Specific performance. An equitable remedy ordering the breaching party to fulfill their contractual obligations exactly as promised, available only when the subject matter of the contract is unique, such as real property or a one-of-a-kind work of art, and money damages would be an inadequate substitute. Uniqueness. The key characteristic justifying specific performance rather than damages, reflecting the principle that when no substitute for the promised performance exists in the marketplace, the only way to truly make the plaintiff whole is to require the defendant to perform. Real property. Land and anything permanently attached to it, which is presumed to be unique for purposes of specific performance, meaning that courts will routinely order specific performance of contracts for the sale of real estate when the seller refuses to close. Specific performance of personal service contract. An equitable remedy generally unavailable for employment or personal service contracts, as courts will not compel involuntary servitude, though they may issue an injunction preventing the breaching party from performing similar services for a competitor. Rescission, the complete cancellation and unwinding of a contract, returning both parties to the positions they occupied before the agreement was made, available as a remedy for fraud, misrepresentation, mutual mistake, failure of consideration, or material breach. Grounds for rescission. The legal basis upon which a party may seek to cancel a contract, including fraudulent inducement, mutual or unilateral mistake, material misrepresentation, failure of a condition, unconscionability, and impossibility or frustration of purpose. Mutual rescission. The voluntary agreement of both parties to cancel their contract and restore each other to their pre-contractual positions, not requiring court intervention as the parties themselves agree to undo the transaction. Judicial rescission. Court-ordered cancellation of a contract after one party establishes legal grounds entitling them to avoid their obligations, accompanied by restoration of any consideration exchanged and compensation for any reliance losses. Reformation. An equitable remedy modifying the written terms of a contract to reflect the parties' actual agreement when the written document fails to accurately express what they genuinely intended due to mutual mistake or fraudulent misrepresentation. Restitution. The equitable remedy requiring a party to return the value of any benefit they received from the other party to prevent unjust enrichment, available both as an independent cause of action and as a component of rescission. Unjust enrichment. The legal doctrine preventing a party from retaining a benefit they received at another's expense when there is no legal justification for doing so, forming the basis of restitutionary claims even in the absence of a contract. Quantum meruit. Latin for as much as deserved, an equitable remedy allowing a party to recover the reasonable value of services they provided when no enforceable contract exists or when a contract has been breached, preventing the other party from receiving the benefit of those services without paying for them. Quasi-contract. A legal fiction imposed by courts to prevent unjust enrichment when no actual contract exists between the parties, treating the defendant as if they had promised to pay the reasonable value of a benefit they received from the plaintiff. Writ. A formal written court order commanding a person, government official, or lower court to perform or refrain from a specific act, representing one of the oldest forms of judicial power and still used today for a variety of purposes. Writ of habeas corpus. The most fundamental of all writs, commanding that a person held in custody be brought before the court so that the legality of their detention may be examined, serving as the primary bulwark against unlawful imprisonment throughout the Anglo-American legal tradition. Writ of mandamus. A writ commanding a government official, agency, lower court, or other public body to perform a ministerial duty they are legally obligated to perform, available only when no other adequate remedy exists and the duty is clear and non-discretionary. Writ of prohibition. A writ issued by a higher court directing a lower court to cease proceedings in a case over which it lacks jurisdiction or is otherwise acting in excess of its authority, preventing the lower court from continuing improper proceedings. Writ of certiorari. The primary mechanism by which the United States Supreme Court exercises its discretionary appellate jurisdiction, granting the writ when at least 4 justices agree to review a lower court's decision, commonly referred to as cert. Writ of execution. A court order directing a law enforcement officer to take action to enforce a civil judgment, such as seizing and selling the judgment debtor's property or garnishing their wages, converting the paper judgment into actual relief. Writ of attachment. A court order directing the seizure of a defendant's property at the outset of litigation to preserve it as security for a potential future judgment, preventing the defendant from dissipating assets before the case is resolved. Writ of garnishment. A court order directing a third party, typically an employer or bank, who holds money or property belonging to the judgment debtor, to withhold and remit those funds to the judgment creditor in satisfaction of an outstanding judgment. Writ of replevin. A court order directing the return of specific personal property wrongfully taken or withheld from its rightful owner, allowing the owner to recover the actual property rather than merely its monetary value. Writ of coram nobis. A writ available in limited circumstances to correct a fundamental error of fact in a criminal conviction that was unknown at the time of trial, and that, had it been known, would have prevented the judgment from being entered. Extraordinary writ. Any of the prerogative writs, including mandamus, prohibition, certiorari, and habeas corpus, that courts issue in exceptional circumstances outside the ordinary course of appellate review, typically only when no other adequate remedy is available. Stay. A court order temporarily halting the enforcement of a judgment, execution of a sentence, or continuation of proceedings while a related matter, typically an appeal, is pending, designed to prevent irreparable harm during the review process. Stay of execution. An order temporarily suspending the carrying out of a sentence, most commonly a death sentence, while legal challenges are pending, providing additional time for judicial review without allowing the punishment to be carried out prematurely. Stay pending appeal. An order halting enforcement of a trial court's judgment while the losing party pursues an appeal, preventing the prevailing party from immediately collecting on the judgment or enforcing an injunction before the appellate process is complete. Automatic stay. A stay that takes effect immediately upon the occurrence of a triggering event without requiring a court order, most notably in bankruptcy cases, where filing a petition automatically halts all collection actions against the debtor. Lifting a stay. The court's removal of a previously entered stay, either because the underlying appeal or proceeding has concluded, the reasons for the stay no longer exist, or the party who obtained the stay has failed to diligently pursue the underlying proceeding. Bond pending appeal. A security deposit required of the judgment debtor as a condition of obtaining a stay pending appeal, protecting the judgment creditor against the risk that the debtor will be unable to pay if the judgment is ultimately affirmed on appeal. Supersedias bond. The specific type of bond required to obtain a stay of execution of a money judgment pending appeal, set in an amount sufficient to cover the judgment, interest, and costs in the event the appeal is unsuccessful. Laches. An equitable defense asserting that the plaintiff unreasonably delayed in asserting their rights, and that this delay has prejudiced the defendant, justifying denial of equitable relief, even if the applicable statute of limitations has not yet expired. Unclean hands. An equitable defense asserting that the plaintiff seeking equitable relief has engaged in misconduct related to the subject matter of the litigation, invoking the maxim that one who comes to equity must come with clean hands. Waiver. The voluntary and intentional relinquishment of a known right, which may serve as a defense preventing a party from asserting that right in litigation if they have previously and knowingly abandoned it through their words or conduct. Estoppel. An equitable doctrine preventing a party from asserting a position that is inconsistent with their prior conduct or representations when another party has reasonably relied on that conduct or those representations to their detriment. Promissory estoppel. A doctrine enforcing a promise that was not supported by consideration when the promisor reasonably should have expected the promisee to rely on the promisee did in fact rely, and injustice can only be avoided by enforcement. Equitable estoppel. A defense preventing a party from taking a legal position that contradicts their prior representations or conduct when the opposing party has reasonably and detrimentally relied on those representations or that conduct. In pari delicto. Latin for in equal fault, an equitable defense asserting that the plaintiff is equally responsible for the wrong from which they seek relief, typically barring recovery when both parties engaged in the same unlawful or wrongful conduct. Unconscionability. An equitable doctrine allowing courts to refuse to enforce a contract or specific contract terms that are so one-sided, oppressive, or fundamentally unfair that enforcement would be contrary to good conscience, divided into procedural and substantive components. Frustration of purpose. A contractual defense excusing a party's performance when an unforeseen event, not caused by either party, has destroyed the fundamental purpose for which the contract was made, even though performance itself may still technically be possible. Impossibility. A contractual defense excusing performance when an unforeseen event has made it objectively impossible for the party to perform their contractual obligations, such as the destruction of the specific subject matter or the death of a person whose services were contracted. Impracticability. A modern and broader version of impossibility, excusing contractual performance when an unforeseen contingency has made performance commercially unreasonable and fundamentally different from what was originally contemplated, even if not strictly impossible. Constructive trust. An equitable remedy imposing a trust relationship on property held by a person who acquired it through fraud, breach of fiduciary duty, or other wrongful means, requiring them to hold the property for the benefit of the rightful owner and transfer it upon demand. Resulting trust. A trust implied by law when property is transferred under circumstances suggesting the transferee was intended to hold it for the benefit of the transferor or another person, arising from the presumed intent of the parties rather than wrongful conduct. Equitable lien. A court-imposed security interest in specific property belonging to a wrongdoer, granted as an equitable remedy to secure a party's right to restitution or damages when the wrongdoer holds identifiable property that would otherwise be available to them. Tracing. The equitable process of following misappropriated funds or assets through a series of transactions to identify their current form or location, essential for imposing a constructive trust or equitable lien on wrongfully obtained property. Accounting. An equitable remedy requiring the defendant to provide a detailed accounting of all profits earned through wrongful conduct, such as breach of fiduciary duty or misappropriation of trade secrets, and to disgorge those profits to the plaintiff. Disgorgement. The equitable remedy requiring the wrongdoer to surrender all profits gained through their misconduct, regardless of whether the plaintiff suffered a corresponding loss, designed to prevent the wrongdoer from benefiting from their own wrong. Subrogation. The equitable right of a party, typically an insurer, who has paid another's debt or loss to step into the shoes of the party they compensated and assert that party's rights against the responsible third party. Indemnification. The right of a party who has been held liable to seek reimbursement from another party who is ultimately responsible for the loss, either through a contractual indemnity clause or through equitable principles imposing the loss on the party most at fault. Contribution. The equitable right of a party who has paid more than their fair share of a common liability to seek reimbursement from co-defendants or other jointly liable parties for their proportionate share of the total obligation.